Well, hello and welcome everyone to this live stream session. Thank you so much for being here with me today. I'm Lior Samfiru, the employment lawyer, and what you're doing here is you're watching my live stream on employment law. Again, I'm the employment lawyer, Lior Samfiru with Samfiru Tumarkin LLP. I'm one of the founding partners, and you can find us across Ontario, BC, and Alberta. And I'm here right now live to take your questions about employment law, to answer those questions, to make sure that you have the knowledge that you need if you're facing a workplace issue. The law is there for you. The law can help you if you're dealing with the workplace issues. What kind of issues can the law help you? Well, it can help you if you lost your job, to make sure that that's done correctly, that you're getting what you're owed. It can help you if you're being mistreated in the workplace, if you're being bullied, harassed. It can help you if you're being discriminated against. It can help you if your job is changing, or your hours, your pay, you're being demoted, relocated, told to come back to work in the office instead of working remotely. You name it. In all those situations and so much more, the law provides solutions and answers and options. And on this session, I tell you what those are, I help you understand those rights, and I empower you with knowledge. Knowledge is power, right? I'm sure you've heard that before. That couldn't be more true than when it comes to employment law. If you don't know your rights, if you don't know what the law can do for you, you're going to walk away from entitlements. So let's not allow that to happen. Don't make it happen. Right now, you have an opportunity to ask a question, to type in that question, hit enter. I will see the question, I will read it, and I will tell you what you need to know by answering it. Again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. Let me give you some other contact information. If you want to connect with me and my team off social media, if you want to have a private discussion, very, very easy to do that. All you do is you go to employmentlawyer.ca. Again, employmentlawyer.ca. And when you go to employmentlawyer.ca, all the contact information you ever need is right there at the click of a button. You have phone numbers, email addresses, fax numbers, social media contact information. It's all there at employmentlawyer.ca. So use that, take advantage of that. Again, I'm Lior Samfiru, the employment lawyer. I'm going to start answering questions right now. But as you're listening to me or watching me, please ask your question as well. I want to be on my toes. I want to be answering so many questions that by the time the session is done, I need to go have a bit of a rest, because you've kept me on my toes. Please do that. I want to make sure you're being helped. I see questions have come in. Let's start answering them. Again, I'm Lior Samfiru, the employment lawyer, waiting and asking for your questions. All right, Mary Ann has our next question. She's joining us from YouTube. Mary Ann says, I took maternity leave and was supposed to return to my same position, but my employer says it's been restructured and is offering me a lower role instead. Isn't that against the law? What recourse do I have to get my old position or compensation? So you're right. Your employer can't just decide to give you a different role, okay? They cannot. That said, if that restructuring is something that did happen, and it would have happened even if you were not there, maybe it's a major restructuring they were going through, and because of that, your job ended, and it would have happened even if you had never taken parental leave, then it's not illegal, but you're still not obligated to accept a lower level position. So if they restructured, or they're coming up with an excuse not to bring you back to the same role, that's potentially a human rights violation. That's an employment standards violation. If the restructuring is legitimate, it's not a human rights violation, but it could certainly be a constructive dismissal. Remember, an employer does not have a right to just change your job, to reduce your hours or your pay, or to demote you. So, Marianne, if that's what they're doing here, if they're essentially demoting you, you can potentially treat that as a constructive dismissal and get your full severance. So constructive dismissal for sure, potentially much more than that, potentially also a human rights violation. So here's the best advice. Let's connect. Reach out to me. I want to actually speak to you. I want to find out more about the job that you had before, the new job that they're offering you, what this restructuring was, when it happened, who was affected by it. I want to know all these things so I can properly advise you. But certainly, anytime you're on a parental leave and you're coming back and your employer says that job doesn't exist, that doesn't look good. It really starts looking like something illegal. They generally have to keep your job open, same job, same pay, same responsibilities, etc. So you know what to do, Marianne, to connect with me off air, off live stream. Very easy to do. Just go to employmentlawyer.ca. See that address on the screen over there, employmentlawyer.ca. Thank you for that. Glad you've asked the question. I hope you see how easy it is. If you're just joining us, I'm Lior Samfiru, the employment lawyer with Samfiru, Tumarkin, LLP, and I'm here live answering questions about employment law. I see some more questions have come in. I'm going to answer them, but man, keep me busy. If you want to know something, if you always wanted to know something about your rights in the workplace, you're in the right place at the right time to get that answers, to make it happen. So please ask your questions. Don't be bashful. All right, next question today comes from Midnight Bluey. Can you talk about termination for incapacity in a union government environment? I can't, because it does depend on the collective agreement, and your union is the only one that can advise you. So by the way, anything you hear me say on this live stream, or you see me on TV talk about, or you hear me on radio talk about, none of that applies in the unionized environment. It only applies to non-union environments. In other words, it applies to employment law. Union environments is labor law. We're talking employment law. So unfortunately, can't help you with that. You would have to ask your union as to what your employer can do and cannot do, and only the union is allowed to help you and advise you. So thank you for that, Midnight Bluey. Again, if you're just joining us, I'm Lior Samfiru, the employment lawyer with Samfiru, Tumarkin, LLP, here answering your questions about workplace rights, employment law, and all those things you need to know if you're having a job and maybe things are not going great. Your boss gave you some sort of an ultimatum. Your job is changing. Maybe you have a situation where you've been put on a temporary layoff. How long can that last? Is it even legal? We can talk about that and so much more. And it starts by you asking a question. Give me the opportunity to help you. All right, just like our next question from Jason, who is joining us from Facebook. I signed a non-solicit agreement when I joined my employer in 2020. I am now moving to a competitor, but a few of my old clients have reached out to me directly. Am I allowed to respond to take them on, or could my former employer take legal action even though Ontario banned non-competes? Okay, so they banned non-competes. They did not ban non-solicits. Non-solicit means that you cannot go to your old clients and convince them to leave you. So here's the thing. A non-solicit or a solicitation often comes down to who made the first move. So if you are leaving and you're contacting your former clients and say, hey, clients, I'm here, come join me, that's solicitation. On the other hand, if they come to you and say, hey, Jason, I heard you're over there, we want to come work with you, you're not soliciting. You're absolutely able to do that. So if you signed a non-solicit, it's important that it's clear who made that first move. So I want you to have some sort of a record. Hopefully there's something in writing, an email, something that shows if you're ever challenged, that no, I didn't go after anyone. They came to me. As soon as they heard I was leaving, they said, hey, I want to go with Jason. Jason's great. I love Jason. That's okay. So don't solicit if you sign a non-solicitation. That could be problematic. You could face legal action. That's very different than a non-compete. Non-compete simply says that you're not allowed to work for a competitor. For most people, that's not legal. A non-solicit for most people is legal, and it comes down to who made that first move. Okay, so hopefully that's helpful, Jason. If you're not sure what this means, if you're not sure if you've solicited or not, or if your former employer is giving you a hard time, man, you've got to reach out to me as soon as possible, okay? Employmentlawyer.ca to do that. Again, employmentlawyer.ca. All the contact information you can ever need is right there, okay? Thank you for that. Great question. By the way, you as well, if you're just joining us, I'm Lior Samfiru, the employment lawyer with Samfiru, Tumarkin, LLP, live right now on this platform here, talking to you about workplace rights. And I say I'm talking to you, but what I'm really doing is I'm answering your questions. So you have an opportunity. You got me here, my undivided attention. Ask me your question about workplace rights, employment law, your job, your boss, your compensation, and I will answer it. Just like TI1U. How much severance should a worker be offered after 8 years? I'm 39, worked for 8 years in a mid-level position. Fantastic. So the factors that go into assessing your severance are your age, your position, and the length of your employment. So the longer you work, the older you are, and the more senior a position you have, the greater the entitlements. So you're going to be at 39 after 8 years. mid-level position, 8 to 9 months. You're kind of a classic month per year person. So 8 to 9 months is what I would assess you at. What does that mean? That means that if you're let go, your employer is going to have to pay you for, let's say, 9 months as if you were still there. They're going to have to pay your salary, your benefits to be continued, bonuses, car allowance, pension contributions. If you want to know if something would be included, you simply ask yourself, hey, would I have gotten that if I had continued working for the next 9 months? If the answer is yes, I would have, then it has to be included as part of your severance as well. Okay, so that's what that looks like for you. I can almost guarantee you, TI1U, is that if you're let go, what the company is going to offer you is going to be a lot less than that, because that's what happens in 90% of cases. The severance that an employee is offered is a lot less than what they're actually owed. Companies hoping to pay a lot less. So if you're let go, let's chat. Let's make sure you don't accept anything until we've done that. It's not going to be difficult to get you what you're owed, and it starts by giving me a call if you're let go, and you just got to go to employmentlawyer.ca. But before I move on to the next question, something else I need to give you and some other information you need to have. I just assessed how much TI1U is entitled to by way of severance. You can find out how much you're owed as well. Very easy to do, and you don't even need me. We have a tool called the Severance Calculator that allows you to find out in seconds how much severance you are owed. All you got to do is you go to pocketemploymentlawyer.ca. See that address over here, pocketemploymentlawyer.ca. And when you're there, you click on the severance calculator. That's it. You're right there. When you go there, you answer a few questions, and it's going to tell you if you're owed 6 months, 12 months, 24 months, any other amount. It's easy to use. Man, is it easy to use. Completely free, of course, completely anonymous, no names, no phone numbers, no email addresses. It's just there for you. All right. So please check it out. Well over 2 million Canadians, close to 3 million now, have used it already and have found out how much severance that they're owed. You have to find out as well. Maybe you just lost your job and you want to know what's the right severance amount because it's probably not what you've been offered. Or you're worried that something's going to happen, maybe after the holidays, they're going to let you go. How much severance should you be getting? You're going to go to the severance calculator. Or maybe you're just curious. How much severance is for me? Is it 2 months? Is it 6 months? I bet you it's a heck of a lot more than you realize. Just go to pocketemploymentlawyer.ca, use the severance calculator, find out. So thank you for that. And right now, though, I'm still live. You're still live. I want to answer your questions. And all you have to do is ask them. I'm Lior Samfiru, the employment lawyer with Samfiru, Tumarkin, LLP. If you're just joining us, you got time. You got so much more time still to ask the question, so take advantage. And our next question today is on YouTube from Naveen. I've worked for my employer for 6 years as a project lead. Recently, they reduced my salary by 20% temporarily and reassigned me under a junior manager. No one else had their pay cut. I feel humiliated, demotivated. Will this count as a constructive dismissal if I decide to resign? Yeah, of course. Your pay has been reduced by 20% and you've been demoted. Yes, that is a classic constructive dismissal with the cherry on top. Absolutely it is. Your employer is not allowed to do that. It's not a term of employment that your employer can just change like that. That's a massive change. Listen, if they reduce your pay by 1% or 2%, a couple percent, and they left the job otherwise the same, not nice, but they could probably get away with it. But what you're describing, 20% pay cut and a demotion, that's a constructive dismissal. So options, what do you do now? First option is you can say, okay, I'll accept it. I'll continue working. I don't recommend this. If you accept this, you're potentially giving them the right to do it again and again and again. Huge problem. Don't recommend this. Second option, of course, is you can consider this a constructive dismissal, leave and get your full severance. Please, though, if you're going to consider a constructive dismissal, do not quit. Do not do anything until we've spoken, okay? The devil's in the details. I don't want you quitting and then calling me, okay? We talk, we do this right, and then we proceed. So yes, that could absolutely be a constructive dismissal. If you had your terms of employment change in a significant way, you better believe that's not allowed. To connect with me and my team in Ontario, in BC, in Alberta, very easy. Just go to employmentlawyer.ca. Again, employmentlawyer.ca. All the contact information you need is right there. Thank you from that, Naveen. I appreciate that. Look forward to connecting with you as well. starts by asking a question right here, right now on this platform. I see more questions have come in. I'm going to answer them, but don't let this opportunity pass you by. I know you have questions because I answer them all the time. Ask them. It's fine. I got you. Okay, ask your questions. All right, bro has our next question. What if my coworker and I don't get along? I'm supposed to work closely with him. What do I do? So here's the thing, not getting along, not liking someone in itself is not something that you can do much about. Figure out a way to try to coexist. You may not like each other, but ultimately you have to find a way to coexist. If it's more than that, if someone's treating you badly, bullying you, harassing you, intimidating you, wait a second, that's very, very different. That means you have to tell your employer in writing about this, and they have to deal with it. They have to find a way to fix it. Either they have to deal with this person to make them change their behavior, to separate the two of you, to move him on, to discipline him, to let him go. But they have to find a way to deal with it if it rises to the level of harassment, bullying, or a poison work environment. So don't be ashamed and don't be afraid to talk to your employer about it. Again, in writing. I don't want your employer later on to say, oh, you never told us. That's why you put it in writing. But as I said, if it's simply a matter of like, we're very different people, we just don't get along, we have nothing in common, I don't like working with them, that in itself is not something you can do anything about. You can talk to HR and say, hey, is there somehow a way to make this different, to get someone else I can work with? But ultimately, you can't force the issue. Well, you can force the issue if it's bullying, harassment, or poison work environment. So hopefully that makes sense, bro. Any follow-ups? I'm still here. You can ask them, or you can reach me in the office through employmentlawyer.ca. And anyone else, I've answered your question. If you have a follow-up, fantastic. Ask it. I'm not going anywhere yet. I want to make sure that when we hang up today, when we end this session, you've had all those questions answered. Questions have come in, a couple more. I'm going to answer them as well. You have time. We're kind of in the second half of our session, but still plenty of time for you to ask your question. Okay, let's continue. Sherry has our next question. I'm heading into a mandatory HRTO mediation soon. Do you have any advice? Is a half-day session usually enough to resolve a dispute involving multiple allegations, discrimination, retaliation, etc.? So the first piece of advice I'll give you is do not do this on your own. That's the number one advice. If you're going to a mediation where I know the company is going to be represented by a lawyer, and you're doing this on your own, you're at a huge, huge disadvantage. It's like going to have a discussion about medical issues when you're discussing them with the doctor and you're not a doctor. It's not appropriate. It's not a fair fight. So the first thing I'm going to say to you, Sherry, is if you're doing this if you're not doing this with a lawyer, it's not going to end well. And you may resolve it and you think that's a good result. It's probably not a good result. Okay, because you're not going to know, frankly, if something is a good result. How can you assess your own entitlements unless you've had that legal training? Not possible. So that's number one. And by the way, if you have a lawyer, the company is going to be a heck of a lot more willing to resolve with you because they're going to take you seriously. If the company's lawyer is going to think, well, if we don't resolve, we go to a hearing, I'm a lawyer, I'm going to win because I have a lot more experience. If you have a good lawyer on your side, they're going to take you seriously. So that's the number one thing. Now, is a half day enough? Usually, yes. Okay. But again, if you have someone that knows what they're doing, I've done 2,000-3,000 mediations in my career. My colleagues have as well. So that's what you're up against. So Sherry, if you need some help, let's connect. Okay. employmentlawyer.ca. I do not recommend trying to do this alone. Not at all. All right. Again, employmentlawyer.ca to connect. Happy to help you. So let's see. Serial lover. I'm not sure exactly what your comment means, but that's fine. Let's see. The next question is from Joan. I've been suffering from burnout after being given unrealistic workloads and being publicly criticized by my supervisor. My doctor recommended a stress leave, which AR is questioning, saying, I'm not really sick. What protection do I have under the Human Rights Code or employment standards for mental health related leave? It has nothing to do with any of those things. You can be off as long as you need to if you have a doctor's note. Now, your doctor's note does not need and should not say what the medical condition is. If you need to be off work, the doctor's note shouldn't say, oh, you need to be off work because you're suffering from stress. No. All your doctor's note needs to say is you need to be off work for medical reasons. That's it. You have a right to privacy. The specifics of your medical condition, if it's stress, anxiety, or if it's a bad shoulder, is irrelevant. What's relevant is whether or not your doctor says you should be off work. Your employer does not get to question that. Your employer doesn't say, well, we know better than your doctor. Trust us. I'm an HR person. I know a lot better than your doctor. Nonsense. Your employer doesn't get to assess if you're really sick. But if you're providing too much information to your employer, that could work against you. All you have to tell your employers, can you work, can you not, and how long you need to be off. Is it a day? Is it a week? Is it a month? That's it. So, no, your employer doesn't get to question it. They don't get to refuse. You're not asking your employer permission to be off work. You're telling them you're going to be off work. This is not, hey, employer, do you mind? Can you approve me being off work for medical reasons? No. It's employer, here's my doctor's note. As you see in my doctor's note, I'm going to be off starting Monday for 3 weeks. That's it. Goodbye. That's all it is. If your employer gives you a hard time, call me. Okay, let's connect right away. You can do that through employmentlawyer.ca. I think people don't appreciate often just how powerful your doctor is when it comes to allowing you to be off work. Your doctor holds all the power. If your doctor gives you a note that says you cannot work or should not work, you can be off work. And that's it. It's the end of the discussion. It's not a discussion actually at all. You're not discussing this with your employer. You're not talking with them about it. It's simply that simple. And in that situation, yeah, you're off work. Employers may often ask you questions. Well, I need to know what your condition is. I need your medical file. I need your doctor to tell us what it is that you're suffering from. No. That is personal information that's irrelevant. They don't have a right to know that, so don't provide that information. Any problems, you reach me through employmentlawyer.ca. If you're joining us for the last 7 or 8 minutes, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP across Ontario, BC, and Alberta. And I'm still here live wanting your questions. I see more questions have come in. You have time still, even now, to ask a question and get an answer right here in the next few minutes on this session. So take advantage, ask your questions, and make sure that you know what the law can do for you. All right. Eileen has our next question. My employer just blindsided me with a change to my work location. It's an extra hour of driving each way. Do I just have to accept this? No. So that comment that you just made, an extra hour each way, that's really the threshold that I use. So if it was like, yeah, it's 20 minutes, probably not much you can do about it. But if it's an extra hour each way, more than what you're currently having, that could easily be a constructive dismissal. It's a significant change to the terms of your employment. So the options are, yeah, of course, you can accept it and commute to the new location, or you may be able to treat this and consider it a constructive dismissal and leave with your severance. Now, you can't physically stop your employer from doing that, but what you can do is to say, well, I'm not okay with it. So if you're going to do that, that's a constructive dismissal. I need my severance. So, of course, before you quit, before you do anything, or even tell your employer, no, let's talk. Devil's in the details. I want to make sure that it hasn't happened before. I want to see any employment agreement that you've signed. So again, devil's in the details. But once we are kind of in that hour time frame, that is a constructive dismissal. It's a big change. Once we're at an hour, we're now at that major big change. It's no longer just a small minor one. So that's where we're talking constructive dismissal here, Eileen. So to connect with me, if you want to pursue this, if you want to know more so we can dot our I's and cross our T's, employmentlawyer.ca, the way to do that. Again, employmentlawyer.ca. Great question. Love the question. And I want to continue answering, so I'm going to answer yours. D'Angelo has our next question. The boss just sold the business. It's a small company, worked here for about 8 years. There's been no mention of changes from the new owners. Is there any timeline for them to end my employment? Do my years carry? So if you're continuing to work with them, so business is sold, you're now working for the new company, they inherit your service. So that's fine. They can let you go at today or tomorrow or 10 years from now, anytime, because an employer is always allowed to let you go as long as severance is paid. So they can let you go at any time, like any employer could, but they're going to have to pay severance, and that severance is going to have to account for the 8 years you had with the previous company. Now, here's the key, and hopefully it's not too late for this. The key is the employment agreement that you sign with your employer, with a new company, when you join them. So I want you to be very careful with that, because I just told you that they inherited your service. There's a way in that employment agreement to have a term that says, we're not going to inherit your service. So you could potentially give up those previous 8 years by signing an employment agreement that says that. So I want to make sure that the employment agreement that you signed did not say that, in fact, okay? And if you're going to be asked to sign an employment agreement, I want to see it before you sign it. If they're not asking you to sign an employment agreement, just, hey, so we bought the business, you're starting Monday, that's fantastic. That's good news. You don't want an employment agreement. That's great. But if they ask you to sign one, or going to ask, we need to see what that means, what it does, because you don't want to give up on your past service, okay? You don't. They inherit it automatically unless you sign something that says otherwise. That's the best way to put it. If you want to connect with me, D'Angelo, I'm employmentlawyer.ca. You can even ask a follow-up question. But again, you can reach me through employmentlawyer.ca. Let's see if we can take another question or two. Facebook comes our next question. This one's from Liam. I worked full-time for the same company for 3 years as a contractor, but they control my hours, tools, and clients. They're now ending my contract with 2 weeks' notice. Could I be considered an employee? And if so, could I be owed severance or vacation retroactively? Absolutely, yes, yes, yes. You are an employee, full stop. You work for 3 years full-time where they control your work. Of course you are an employee. You couldn't be more of an employee if you tried. Doesn't matter what they call you. Doesn't matter what piece of paper you may have signed. If you are an employee in the eyes of the law, then that cannot be changed. So that means now that they let you go, they owe you severance. So listen, after, 3 years, you're probably owed 4, 5, even 6 months of severance. Not weeks, months. Yes, you're owed vacation pay retroactively and overtime and holiday pay. So this is a classic case of being misclassified. Happens all the time, and it's not legal. It's not legal, and the government, by the way, is cracking down on that. CRA could have problems with that. So let's make sure that you get what you're owed. So Liam, connect with me through employmentlawyer.ca, and I'll help you get the compensation that you're owed. Okay, again, employmentlawyer.ca. I think I got time for one last question. Let's take that last question from Derek. I believe that my work will fire me once I return from STD. That's short-term disability. Wanted me to sign extension to the probation period while on leave. What are my options? Well, first of all, don't sign any extension to anything. If they let you go, that could potentially be a human rights violation. They're certainly going to owe you severance as well. They can't let you go because you were off on a disability leave. If it's unrelated, they just don't have a job anymore, then it's just a question of severance. In many cases, if the company is not even going to look to bring you back, that could be not just a severance issue, but also a human rights violation. Potentially means that you're owed additional compensation, additional damages. So Derek, for now, focus on getting better and getting healthy. Do not sign anything. When you're ready to go back to work, tell your employer in writing, hey, I've been cleared, I'm ready to come back to work. If they take you back, no problem. If they don't take you back, you call me right away. I will make sure that you get what you're owed. To connect with me, of course, employmentlawyer.ca. You see that over here, employmentlawyer.ca. Thanks for that, Derek. And thank you guys as well for all the fantastic questions today. Really, really good questions. I'm glad I had this opportunity to sit here with you and answer those questions. So now that we're done, though, the conversation is not ending. You can still connect with me and my team privately so we can have that discussion. Just go to employmentlawyer.ca. Phone numbers there, email is there. Everything you need is there. Again, employmentlawyer.ca. I'm Lior Samfiru, the employment lawyer with Samfiru, Tumarkin, LLP. If I haven't got to your question, no problem. Again, employmentlawyer.ca to connect with me and my team. No problem to do that. I want you to do that. Guys, I'll be back here very soon. In the meantime, you know what to do, employmentlawyer.ca. I'm Lior Samfiru, wishing you all the best. Thank you.